Hey guys, welcome back to the channel. Today we are going to talk about constructive notice. Now, what is constructive notice? In simple terms, constructive notice is a legal doctrine that presumes a person should have known something, even if they didn't actually know, because the information was publicly available or easily accessible. It's often contrasted with actual notice, where someone is directly informed of a fact. This concept commonly applies to transactions involving property, companies, or contracts. The idea is that if the information is publicly accessible, such as in a government registry, a party is expected to be aware of it. Ignorance is no excuse when the facts are there for you to discover. Now, why is this important? Constructive notice plays a significant role in commercial and property transactions because it places the responsibility on individuals to do their due diligence. For example, when purchasing a property, you are expected to check the land registry to uncover any encumbrances like mortgages or charges. Failure to do so doesn't protect you from these obligations because the law assumes you should have known about them. So how is constructive notice applied? It is applied in several contexts, especially in dealings with property law and company law. As mentioned earlier, in property law, constructive notice can arise when a person buys a property. If there's an encumbrance such as a prior mortgage registered in the land titles registry, the purchaser is assumed to know about it. So even if the buyer claims ignorance, the law presumes they had notice because the information was publicly available. In company law, constructive notice often applies to the memorandum and articles of association, which is now called the constitution of a company. When dealing with a company, outsiders are assumed to be aware of the company's constitution and its limits on the powers of directors. This means that they cannot later argue that they were unaware of certain restrictions that were clearly stated in the company's publicly registered documents. Let me give you an example of how constructive notice applies in property law. Suppose Mr. Tan buys a piece of land. He pays a huge sum of money, but later finds out that the land has an existing mortgage registered against it. Mr. Tan claims that he wasn't informed about the mortgage. However, the court rules that since a mortgage was registered in the land registry, he had constructive notice of it. He cannot avoid liability for the mortgage simply because he didn't check the public records. In another case, imagine a supplier enters into a contract with ABC Private Limited. After delivering the goods, ABC Private Limited refuses to pay, claiming that the director who signed the contract had no authority to do so under the company's constitution. The supplier argues that they were not aware of this restriction. However, the court finds that the supplier had constructive notice of the company's constitution. Since the constitution was publicly available, the supplier was expected to know about any limitations on the director's powers. To sum up, the law of constructive notice serves an essential purpose in making sure that parties take responsibility for conducting due diligence, whether it's checking public records in property transactions or reviewing a company's constitution. The law assumes that if the information is available, you should know it. Thanks for watching. If you found this video helpful, don't forget to like, share, and subscribe. I'll see you in the next video.